If you are a parent, there are certain phone calls you never forget. The one where the school nurse calls because your child is sick, the one where the principal calls because there was an incident, and then there's the calls that start with, we are considering suspension, or we need to talk about expulsion. Those words land like a punch. You might hear almost nothing after them. Terms like code of conduct or code violation, zero tolerance, alternative placement, or board meeting. Those words can swirl together, and all you can think of is my child going to be kicked out of school? Well, today we're going to slow that a moment. We're going to slow down, and we're going to talk about how K through 12 discipline actually works, what short-term and long-term suspension really means, what expulsion and alternative placements really are, and what your rights are, what your child's rights are, and what rights they have along the way. Now, we cannot make the phone call pleasant, but we can make it a lot less confusing. This is Legally Blind Justice, brought to you by K. Altman Law. I'm your host, Dr. Amanda Stewart. Now, welcome back to Student Defense Programming. In episode 1, we gave a big picture overview of student discipline in both K-12 and higher education. Well, today we are zooming right in on K-12, suspensions, expulsions, and alternative placements. These are the decisions that can reshape your child's school career, and sometimes based on how a single incident occurs, or sometimes based on a pattern that has been building for years. Now, to help us unpack this, I'm joined today by Student Defense Advisor, Dr. Tracy Lewis. Tracy works closely with families across the country who are trying to navigate school discipline in real time, and often with very little notice. Tracy, thanks for joining me today.
Thanks, Amanda. This is the episode most parents wish they had heard before they ever got the first suspension notice.
That is so true. So let's start with some definitions. You know, as former teachers, we love definitions.
Absolutely.
So we're going to start with definitions because schools tend to use discipline language as if everyone already understands it. When we say short-term suspension, long-term suspension, and expulsion, what do those words really mean in practice?
Well, the specifics can vary by state and district, but there are some common patterns. For instance, a short-term suspension is usually a removal from school for a limited number of days, often up to 10 days for a single incident. It's still serious, but it typically stays within the lower range. A long-term suspension is a removal that lasts beyond that short-term window. It might be 20 days, 45 days, or even the rest of a semester or school year, depending on the jurisdiction and the code of conduct. Now, expulsion is the most serious. It usually means the student is removed from their school for an extended period, sometimes for the remainder of the school year, and in some places for a full calendar year. It can also mean that the student is barred from attending any school in that district for that period.
And we know from experience, it also means that students can be barred from any, in 99.9% of the time, they're barred from school activities also.
Exactly.
And then somewhere in that mix, you often see phrases like alternative education placement or disciplinary reassignment. What does those typically look like?
So that's when the school says, we are not expelling your child, but we are removing them to a different setting. Often a separate alternative school that serves students with discipline records or a different program with more restrictions. From a legal perspective, those moves can be as impactful as an expulsion, especially if the new placement is stigmatizing, less rigorous, or difficult to get to. Parents sometimes agree to them thinking this is better than an expulsion, without realizing that they're signing off on something that changes their child's trajectory. I'm sorry.
Mm-hmm. You're right. Now, Tracy, as a former school principal, I know you've had to make the difficult decision to refer a student for suspension, expulsion, or even an alternative placement. Can you provide our audience what goes through your mind when you have to make that recommendation?
Well, we look at a few things when we make that recommendation. My experience was always to try to keep the child engaged in their education as much as possible. However, when you're looking at whether or not this is just a suspension, whether it's a expulsion or an alternative placement, I would always have to think about the severity of the issue. What was the conduct? What effect did it have on not just the student and the immediate students involved, but what effect did it have on the school as a whole? What effect did it have on the environment? Lingering effects will this have on an environment? What are what is the rationale for removing the student from the environment and for how long? Oftentimes, we would look at the student's discipline record. Is this just a one-time thing that we feel like we can restore after some type of consequence? Or is this something that happens over and over again, and we've tried different measures to address it, but it still keeps becoming a problem? So there are many different things that you look at when you are having to make a decision. Always trying to be careful because you are dealing with a young person and you are dealing with an impressionable person, and you want to do what's in the best interest of not only that student, but the school environment as well.
Thank you, Tracy, for sharing that. That's one of the reasons why I just love you being on the team and one of these student defense advisors. Because when we do get those cases where the student is in K through 12 and, the parents have received that phone call that talks about suspension or expulsion or alternative placement, you're really primed and ready to really challenge what administrators, the decisions that they're making. Because sometimes, as you know, we have evidence where administrators, they're not given all that thought that you just shared with the audience. So I'm so grateful you have that experience so we can help hold school administrators accountable, but just also give them the opportunity to look at it from different perspectives. So thank you for
Exactly.
sharing that.
Yes. I always have to
Now,
take that into account.
and it's so important. So let's bring this down to earth with a fictional story. Okay. We're going to call this student Jaden.
Mm-hmm.
Jaden is a seventh grade student in a public middle school. He's never been suspended before. One day, the assistant principal calls home and tells Jaden's mom, and we'll call her Tasha, that Jaden was caught with a vape pen in the restroom. Now, the school is imposing a 3-day out of school suspension. Tasha's at work. She's flustered, and the call sounds something like this. Mrs. Brown, this is serious. Vaping is against our zero tolerance policy. We are required to suspend him. It's only 3 days. We'll send the paperwork home with him this afternoon. Tasha thinks, okay, 3 days. We can survive 3 days. She tells Jaden to apologize and promises the school it will never happen again. She does not ask for the code of conduct, whether there is a hearing, or what goes on his record. Now, Tracy, what are some issues in Jaden's situation that a parent might miss if they treat this as it's only 3 days?
Well, a few things jump out immediately. First, even a short suspension can go into Jaden's discipline record. If there are more issues down the line, this incident can be used to say he has a history of misconduct. Second, the term zero tolerance gets thrown around a lot. Sometimes the policy really does mandate suspension, sometimes it does not. Without reading the written code of conduct, you do not know whether the school truly had no choice or whether they are just defaulting to the harshest option. Now, third, there's the question of education. During those 3 days, is Jaden supposed to keep up with his work? How? Is the suspension being treated as an unexcused absence? That matters for truancy and grade impact. And finally, if there's any suggestion that the vape pen contains something illegal, the stakes could suddenly jump to a different category, including possible involvement of law enforcement.
So true. We've seen that happen.
Mm-hmm.
So, Tracy, do you agree that even a 3 day suspension deserves more than a resigned, okay, I guess, and that it deserves questions, documentation, and clear understanding of what the school is recording and why?
Absolutely. Um, Even with a 3 day suspension, you need to find out how long is this going on my child's record and how long, what impact is it going to have, what, as we talked about earlier, how is my child going to access their education? How are they supposed to turn their work in once they access that education? And how long will they have to make sure that they are able to get it done? Is it the 3 days that they're out? Will they have days after they return? You have to ask all of those specific questions so that you are sure what is to be expected during that time period, how it's going to affect your child, not only in those 3 days, but in the long run, just as we discussed earlier.
Thanks, Tracy.
Mm-hmm.
Now, let's talk about rights in a suspension context, especially in public schools. At a high level, and without getting into 50 different state statutes, what generally protections should parents expect when a school is considering a suspension?
Again, the details vary, but there are some common threads. Before a significant suspension, the student should usually be told what they are accused of and given a chance to tell their side of the story. That might be a conversation with the principal or assistant principal, or it might be a more formal meeting. Parents should receive written notice of the suspension that explains the rule that was allegedly violated, the length of the suspension, and the dates. In some places, if the suspension will exceed a certain number of days or will convert into a long term suspension, there should be access to a more formal hearing process. During the suspension, schools are often supposed to provide some way for the student to keep up academically, especially as the days add up. The quality of that support varies widely in practice.
So true. Now, what are some challenges you have seen regarding students keeping up with their schoolwork while on suspension?
Oh my gosh, I've seen students not able to access the work that they should have. I've seen students not able to understand the work because they're not there for the instruction. And trying to get that instruction while they're not present in school is oftentimes difficult. I've seen students try to email their instructors, sometimes getting a response and sometimes not. Um, to be very honest with you, I've seen cases where the work just was not provided. It should have been made available, but it wasn't. So those are just a few examples of situations that I've seen. And again, we're talking about academics. That is the whole point. That's our main point of school, is so that our children can receive an education. And sometimes I've seen where suspension truly hinders that education.
Thank you for that. Now tell us a little bit about the reentry process.
Okay. There should be some sort of reentry process after a suspension. Um, that could be a meeting. That could be a plan to address the underlying issues, follow up services such as counseling, such as restorative practices. Though, again, in reality, sometimes it may just be come back on Monday and try not to get in trouble again. Typically, when that happens and there's been nothing done to address the situation, we leave things up to chance.
You're absolutely right about that. I think back, through my career working in the K through 12 setting. I've had a few different principals.
Mm-hmm.
I've seen different principals handle a student's returning from a suspension differently, and I believe, based on my experience, the best process is for the administrators to have a reentry plan. It could be, and most of the time, it was an informal meeting. If the school started at 8 a.m., The administrator would tell the parent, come in with your child at 8:30. Let me clear out the
Mm-hmm.
buses and
Mm-hmm.
let's meet and talk about, the student coming back to school. Um, and of course, in our line of work, we always tell parents that they should take notes during the meeting and then follow up with the school administrator via email. You know the saying, per our conversation. Here, documentation is key.
Yes. And parents always have a right to ask for documentation. Ask for incident reports, witness statements, copies of policies. Take the time to read them before agreeing to anything or signing any statements.
You bring up a good point, Tracy. I find that is the piece of information I think most parents don't know.
I think so. You may not always get everything that you ask for, but you absolutely can ask for it. And you absolutely should read what you are being asked to sign before you sign anything.
That is true. Now, let's move to something more serious.
Okay.
In the beginning, you talked about the terms and you gave definitions for long term suspension and alternative placement. This is where we often see parents pressured into voluntary solutions that are not really voluntary, right?
Right.
So here's another fictional story for you. We're going to call this student Brianna.
Okay.
Brianna is a 10th grade student in a public high school. There's a serious fight in the cafeteria, let's say on a Friday afternoon. Multiple students are involved. Someone brings up that Brianna has argued with one of the other students on social media before. The school reviews the camera footage, talks to a few witnesses, and concludes that Brianna was the primary aggressor. The administrator calls Brianna's parents, calls them in and says, they're considering a long-term suspension and possible expulsion recommendation. Now, in the same breath, another option would be for you to agree to a disciplinary transfer to our alternative school for the rest of the year. If you agree to that, we will not move forward with expulsion. And we need your answer quickly so we can finalize our report. As you can imagine, Brianna's parents are terrified of the word expulsion, so they signed the transfer paperwork right there on the spot. Now, Tracy, what are the problems with how this was handled?
There are several red flags with this. First, the family was presented with a high stakes choice: expulsion versus alternative placement, without meaningful time to review the evidence, understand the process, or get advice. That is not a real choice. That is pressure. Second, the school framed the transfer as a favor. We will not move forward with expulsion if you do this. But an alternative placement for the rest of the year can be functionally similar to a long-term exclusion, from the regular school environment, with a stigma that follows that student. Thirdly, we do not know whether the investigation was thorough. Did they talk to all relevant witnesses? Did they consider whether or not Brianna was defending herself? Was there any prior pattern of threats or bullying? The family did not get to test any of that because they signed before they were able to see all of that information. And fourth, by accepting the transfer, Brianna's parents may have limited their ability to challenge the underlying allegations later because the paperwork may say, agree to the findings.
That's so true.
Mm-hmm.
So, one core message here, Tracy, that I'm hearing is parents, do not sign away your child's educational placement in a 15-minute meeting, especially if words like expulsion, permanent record, alternative placements, anything like that are being used to just hurry you along.
Exactly. You can say, we need time to review this. Please give us the written report and the policies that you're relying on. We will get back to you once we've had a chance to view it all.
And Tracy, I will tell you, I had a client before and they came to us And on a Friday afternoon, they got the call to go to the school, and the school administrator said, to avoid expulsion, we want to move your child to online learning, but you have to make the decision right now and sign, and then they'll start the online learning on Monday. I can only tell you I was shocked to hear that, but I know that it happens.
It does. It
Mm-hmm.
does. And that's just not fair. It's not a fair process at all.
If it was, I always say, if it was the administrator's child, they wouldn't want their child or them to be treated that way.
Exactly.
Mm-hmm.
Exactly. And they wouldn't be pressured into making a decision in a 5 or 10 minute conversation.
Mm-hmm. Yeah.
Mm-hmm.
And the one thing in that case, I remember the parent kept saying to me, it was a Friday. It was a Friday. It was like 3 o'clock, 4 o'clock in the afternoon. It was a Friday. And that just stuck
Mm-hmm.
with me all these years later.
Yeah.
So
Yeah.
mhm. It happens, unfortunately.
It does. It's sad.
Mm-hmm. Now, I find that sometimes and this goes in line with what I just shared. I find that sometimes parents contact us after they've signed the documents.
Mm-hmm.
Then when they meet with their student defense advisor and we explain their students' rights, parents then say, we wish we had known,
Yeah.
you know. And
Yeah.
this is one of the reasons why I thought this topic is especially important to bring today during the podcast.
Agreed. And I hope that people are able to take advantage of seeing this and really taking it to heart, and taking notes to know what they have a right to do before they sign anything regarding their children and their discipline.
Mm-hmm. I agree.
Mm-hmm.
Now, a few minutes ago, when we were talking about the reentry plan, I alluded to documentation, documentation, documentation. Parents often ask, what should I be writing down or collecting during all of this? When a discipline crisis hit, what kinds of documentation can make a real difference?
Well, we start with the basics. Keep copies of all of the emails, any letters, and notices from the school. Screenshot any online portals where messages appear in case something changes later. Make sure to write down dates and times of phone calls. Make sure you include who called, what they said, and what you said. And after the call, it's often helpful to send that short follow up email. Something like, "Thank you for speaking with me today. My understanding is that whatever the situation was," and then summarize the key points. That creates a written record. Also, ask for the incident report. Ask for witness statements if they exist. And the relevant section of the Code of Conduct. You cannot get every internal note, but you can usually get the main report and the policies that are being applied. If your child has been dealing with an ongoing issue, something like bullying, harassment, or repeated conflicts, gather the prior emails that you sent about it, log what your child has reported, and any responses that you've received. That context can be extremely important when the school wants to treat the most recent incident as if it came out of nowhere.
Mm-hmm. That's true. And then
Mm-hmm.
also in your documentation, unfortunately, when you do send those emails and parents don't get a response, it's important to note that also.
Exactly. Yes. Mm-hmm.
You know, I'm thinking that this is where like having an incident log or just a simple notebook can be very powerful,
Mm-hmm.
right? Let's
Yes.
say you have 2 or 3 kids in K through 12 setting, you can do just a simple notebook for every child.
Mm-hmm.
Um, if you have already been tracking dates, behaviors, or outreach to your school, and you have it all in the notebook, you can walk into a discipline meeting with more than just your memory.
Exactly. And it
Mhm.
shows a pattern. And patterns really do matter when it comes to discipline. Patterns are very important because they create the picture, they tell the story.
So true,
Mm-hmm.
especially like when you were saying earlier, when a child is being bullied and harassed,
Mm-hmm.
and then they get in a fight. Well, if a parent has reported that 10, 15 times that little Johnny has been, picking on my son, has been bullying my son, the parent walks into that meeting with that evidence of who they told, when did they tell that person, when did they, have that conversation or email that person, and
Hmm.
what the response was, or if no response was received. So,
Exactly. And
mhm.
that's big. That is huge. What was that response? Again, we talk about restorative and having those meetings when students come back from those suspensions or when they're out of school. But again, if we're not doing anything to address the issue, then that causes even more problems sometimes. So, absolutely.
Mhm. We've seen it, unfortunately.
Hmm.
Now, we cannot talk about K through 12 discipline without talking about students with disabilities and behavior plans. Um, Now, we're going to keep it at a high level since there are a full season worth of content just on special education. But what should parents know when a student with an IEP or 504 plan is facing discipline?
Okay. Well, the big idea is that in many situations, schools are supposed to look at whether the behavior is related to the student's disability and whether the school has been providing the supports and services the student is supposed to have. For students with IEPs, when removals reach a certain number of days, or when the school proposes a significant change in their placement due to behavior, there's often a requirement to hold what's called a manifestation determination. Now, that's a meeting where the team asks, in essence, what is the behavior caused by? Was this behavior caused by or directly related to the student's disability or the school's failure to implement the IEP? Now, if they answer yes, in other words, if this behavior, yes, it was related to this child's disability, or if the school did not implement the IEP, the rules for discipline can change dramatically, and the focus is supposed to shift to adjusting supports rather than simply punishing the student. For students with 504 plans, there are also protections against discrimination based on the disability, and schools need to consider whether accommodations were in place before imposing harsh discipline.
So, if your child has an IEP or a 504 plan and the school is suddenly talking about long term suspension, expulsion, or alternative placement, you should be asking very specific questions about whether a manifestation determination or similar process is required.
Yes, and you do not have to figure out those legal thresholds alone. That's exactly the kind of situation where pulling in a special education attorney or advocate alongside a student defense team can make a huge, huge difference.
So true. We have seen it
Hmm.
every day.
Yes.
And so let's talk about another student. Fictional story here, this time involving a student with a disability. We'll call this student Leo.
Okay.
Now, Leo is a fourth grade student in a public school. Leo has ADHD and has a history of impulse control. Has a history of impulse control issues.
Hmm.
He has an IEP that provides a behavioral intervention plan, frequent breaks, positive reinforcement strategies. On paper, it looks decent. In reality, the plan is barely being used. His teachers are overwhelmed. The classroom is always chaotic, and Leo is constantly getting in trouble for blurting out, leaving his seat, arguing with other students or even the teacher. Now, his parents has emailed the school multiple times asking for help, but they mostly just get, we're doing our best.
Hmm.
Now, one day after being teased by another student, Leo snaps. He couldn't take it any longer and he pushes over a desk. The desk then hits another student. Now, no one is seriously hurt, but The principal calls Leo's parents in and announces that the school is recommending a long-term suspension and possible alternative placement because of ongoing aggressive behavior. Now,
Mhm.
Tracy, what should Leo's parents be asking before they just simply sign off on this?
Well, they should be asking whether the school has been implementing his IEP and behavior plan as written. And they should be asking whether the school is required to hold a manifestation determination before removing him for an extended period of time. They should ask to see the data on how often the behavior plan strategies were actually used, what supports were in place on the day of the incident, and how the school responded to their prior emails about his escalating behavior. They should also ask whether other students were involved, especially if he was being teased, and whether the school has documented that. So a lot of things need to be looked at in that situation.
I agree. Now, in other words, the question is not just did Leo do something wrong, right? It is
Mhm.
also has the school done what it was supposed to do for months leading up to that day?
Exactly.
And is the behavior connected to his disability of ADHD that the school already knew about?
Exactly. That doesn't mean that there are never consequences. It means the law often expects more than a simple, he broke the rule, so we're sending him away.
Hmm. That's true. Thank you.
You're welcome.
Hopefully, Leo will get the assistance and supports that he needs, right?
Exactly.
Yeah.
Make the
Well,
modifications and adjustments to the behavior plan that need to be in place.
that's true. And this is one of the times I can add that as an student defense advisor, I've sat in those manifestation determination meetings and
Mm-hmm.
I have the behavior plan and I'm asking questions. Well, okay, did you do A? Did you do B? Did you do
Mm-hmm.
C? And
Mm-hmm.
a lot of times I've got no, no, no. Well, the plan states that to help de-escalate the situation, these are the strategies you should use.
Exactly.
Research-based strategies, data's been collected, and it helps this specific student. So in this case,
Mm-hmm.
Leo, that's why having an advisor, and an advocate sitting at the table, or it really helps parents because we
Yeah,
schools are responsible for following those plans.
they are. And sometimes it's a lot for the parent to navigate alone. And so I agree with you. That's why having an advocate goes a long way and can be very helpful.
Hmm. So true. Now, another theme we hear a lot about in discipline conversation is safety. Administrators will say we have to send a message, or parents expect us to take a hard line, especially when the incidents are like high profile, a fight that ended up on social media, a threat, or something related to weapons. Now, Tracy, how should parents think about safety arguments when they're trying to advocate for a fair outcome?
Okay. Well, first, it's completely legitimate for schools to care about safety. Nobody is arguing with that. But safety should not be used as a blanket check to throw proportionality, facts, and context out of the window. A single poorly worded joke about blowing up a test is not the same as a credible threat. A shove in the hallway is not the same as a planned assault. So parents can acknowledge the school's safety concerns while still insisting on a careful look at what actually happened, what the student's history is, and what the range of responses is appropriate under the written code of conduct. They can ask, how did you distinguish between my child and the other students involved? What specific facts support the level of discipline you're proposing? What positive supports or restorative options did you consider and why were they rejected? There goes that word restorative again. We have to look at all of those things.
And I agree with you. But if administrators take that approach, that approach respects the school's responsibility to keep everyone safe. but does not let we have to send a message replace an individualized fair decision for each
Mhm.
student, each incident.
Yes.
Now, let's get very practical. A parent is listening right now. They might already be in the middle of a suspension process, or they might have just been told that the school is thinking about expulsion. If you were sitting across the table from them, Tracy, what simple steps would you tell them to take this week?
Well, first, get everything in writing. If someone calls you, ask for written notice of any charges, proposed discipline, and upcoming meetings or hearings. Second, read the code of conduct. Find the section about the specific rule your child is accused of breaking, and the section about suspensions, expulsions, and alternative placements. Highlight anything that talks about procedures, rights, or timelines. Third, start an incident log. Write down your child's account of what happened, any witnesses that they name, any relative context prior to the conflicts, any bullying or ongoing issues. Keep adding to that log as the process unfolds. So, as more information comes about, keep adding to that log. Fourth, do not go along to important meetings. If you can't bring an attorney or an advocate, bring another adult who can listen, take notes, and help you stay calm. Tell the school, I'd like to have someone with me. Please schedule the meeting at a time when that is possible. And fifth, if the school is proposing long term suspension, expulsion, or a major alternative placement, get legal advice before you sign anything. That does not mean you are suing the school. It means you are making sure you understand the consequences before you agree to them. That is your right.
Understand those consequences, but and also understand the policies and the processes that the school district should be following.
Exactly. Mm-hmm.
hmm
Yeah.
Now, those steps do not require you to know every law on the books. They just require you to slow down, document, and refuse to rush into life altering decisions for your child.
Exactly.
Yep. Now, if you're listening to this in the middle of a crisis, I want to say something very clearly. Having a child in trouble at school does not mean you are a failed parent or that you failed as a parent. It doesn't mean that your child is beyond help. It means you're dealing with a system that can be confusing, intimidating, and at times unforgiving. Your job is not to fix that system overnight. Your job is to make sure your child is not steamrolled by it. Short-term suspensions, long-term suspensions, expulsions, and alternative placements are not just words on paper. They are decisions that shape where your child learns, who they are surrounded by, and how adults in the system will view them. Those decisions should never be made in rush, without facts or without giving you a real chance to participate in the process. Now, we've created a K through 12 suspension and expulsion incident log template for you. It will be attached to this episode. It includes prompts for what to write down after an incident, space to track calls and meetings, and a checklist of documents to request from your school. And please remember, you'll find that in the show notes on K. Altman's Law's website. Now, if your child is at risk for long-term suspension, expulsion, or alternative placement, or if you are simply not sure how serious a situation is, our student defense team at K. Altman Law can review your documents, explain the process in your state and school district, and help you plan your next steps. You do not have to guess what to do. We're here to help. Now, Tracy, any final words for parents who are trying to sleep at night while all of this is going on?
Absolutely. I would say it is okay to be scared and overwhelmed because this is a lot. But every step you take to get organized, to document, to ask for policies, and to pause before signing moves you from panic to plan. You do not have to do everything perfectly. You just have to keep moving towards an informed action instead of reaction.
I agree 100%, Tracy. Now, in our next episode, we're going to shift from K through 12 to the college world and talk about academic integrity cases and non-academic misconduct. We'll walk through what happens when your college student gets that email saying, "You have been charged with violating the code of conduct," and how to respond without making things worse. Now, if you found today's episode helpful, please subscribe to Legally Blind Justice, leave a review, and share it with another parent, caregiver, or educator who might be facing a suspension or expulsion situation. I'm Dr. Amanda Stewart. Thank you for listening.